A new Connecticut law spans over 120 pages and touches nearly every part of the employer-employee relationship in the state. It's House Bill 5003, now Public Act 26-12. Governor Ned Lamont signed it into law on May 11, 2026. Unlike some of the bills we've covered, this one had broad, bipartisan support. The governor called it a comprehensive, pro-worker package. It's actually a merger of dozens of individual bills that had failed in past sessions, combined into one giant package with 75 sections in total. Many sections focus on public sector jobs, but private employers face real changes too, with most taking effect October 1, 2026. First, pay transparency. Job postings, both public and internal, must now include a wage or wage range, plus a general description of benefits. Before, employers only had to share that information if an applicant asked or once an offer was made. The law also tightens the definition of wage range. It now has to be a range the employer genuinely sets in good faith, not just one they're anticipating. Second, pay code transparency. Employers with 100 or more employees must publish a plain language guide explaining their pay codes for overtime and differentials. Think shift differentials, on-call pay, hazard pay, and holiday or weekend pay. At least 10 codes have to be listed, if that many exist. That guide has to go on the company website in English, Spanish, and any other languages commonly spoken by the workforce. It also has to name a specific person or office employees can contact with pay or timekeeping questions. Third, training repayment agreements, sometimes called stay or pay contracts, get restricted further. These are agreements where an employee has to pay back training costs if they leave a job too soon. Connecticut already limited these, and this act expands those limits. Fourth, retaliation protections. If an employee sues over workplace retaliation, they now have 2 years to file instead of a shorter window. Fifth, lactation accommodations. Connecticut had encouraged employers to provide space and time for breastfeeding employees. Now it's a requirement. Employers must give reasonable break time beyond normal breaks and make reasonable efforts to provide a private space, not a bathroom, with electricity and nearby refrigeration. This rule applies to every employer in the state, even a business with just one employee. Sixth, construction wage theft. Starting January 1, 2027, general contractors become jointly and severally liable for unpaid wages owed by their subcontractors. That means a worker can sue the subcontractor, the general contractor, or both, after giving 30 days' notice. Contractors cannot write a waiver into a contract to escape that liability. The law makes such waivers unenforceable. Seventh, when a company takes over a service contract at certain covered locations, it now has to keep the existing workforce in place for 90 days. That rule starts July 1, 2027. Eighth, workers' compensation expands to better cover employees who are injured in workplace assaults. Ninth, the Act changes how tenured teacher terminations are reviewed, aligning the standard with the one used for other disciplinary actions. Hearings now go before a mutually selected impartial officer or through an expedited process with the American Arbitration Association. Put together, this is one of the most sweeping workforce packages Connecticut has passed in years, covering pay, training, safety, and job security all at once. Employers have a narrow window to prepare. Most of these changes take effect just a few months after signing on October 1, 2026. Wage transparency, pay code guides, lactation accommodations, construction wage protections, and stronger retaliation protections, all under Public Act 26-12. Which of these changes do you think will make the biggest difference? For workers or for employers? Let us know what you think.